That reminded us of the period of Sunil Gavaskar. My lord, we never had wear my lord, the head caps and all that. Only the skull cap was there.
Your arguments, Mr. Dwivedi, have to be very brief.
My argument was?
Arguments have to be very brief. Because Mr. Upadhyay feels that a delay in justice is occurring, so therefore there must be very, very concise arguments and finish. That's his view in public domain.
The world who is watching should see, my lord, that the emotions with regard to Kashmir are not only running in the veins of people of Kashmir, but the whole of the people of India. They are concerned with Kashmir. One way or the other, that's a different matter. Which way the judgment goes is another matter. So let me begin with a deep breath. 14 days of wait, my lord. And with some hiccups. Finally on the pitch. However, my lords, we are dealing with Kashmir, my lord. If one goes to Kashmir, my lord, 14 days are not enough. I think, Mr. Zafar, I will vouch for that. And even a month will be, my lord, less. There's so much beautiful scenery and so much beautiful and nice people, my lords. And a nice culture. So what one thing is there, my lord, with this proceeding, the learned councils, what name? When you play a match on the pitch, then you don't watch the scoreboard. Oh, you forget it. So one thing is clear, my lord, that the learned councils on my right, my lords, they have very ably, my lord, put forward the case for the rights which the people of Kashmir, or at least some of them, feel vest in them, and the desire to see the continuance of 370. Nobody can say, my lord, that the lawyers who are not from Delhi, they have taken full care, my lord, of the interests of those who believe in the continuance of 370, and even the world who is watching should see, my lord, that the emotions with regard to Kashmir are not only running in the veins of people of Kashmir, but the whole of the people of India. They are concerned with Kashmir. One way or the other, that's a different matter. Which way the judgment goes is another matter. But we are all concerned with Kashmir. That's the stature of Kashmir, not in the hearts of all the people, not 1.40 crores. The other aside is, Lord, that I was wondering, Lord, taking a cricketing analogy, just a little aside, Lord, that when we walk into the pitch, the opening batsman, Lord, is one finds with the guards and thigh guards and elbow guards and helmets nowadays. But our Lord, opening batsman, Lord, the learned Solicitor General, when he walked up, he did not walk up any pads, etc. Lord. And that reminded us of the period of Sunil Gavaskar. Lord, we never had wear Lord, the head caps and all that. Only the skull cap was there. So he didn't start by saying, Lord, that these constitutional orders carry the presumption of validity, Lord. These are all available, my lords, to the state to stand up and say, which your lordships, of course, keep in mind. One, that there is a presumption of validity, my lord, which they have to, the burden is on them to show that unquestionably, undoubtedly, the only conclusion is what they are conversing for. The second principle, my lord, is that if there are two views possible, my lords, with regard to 370, so Article 3, then that view should be adopted, which sustains the exercise of power rather than it defeats that exercise of power. So the burden on them is to show that what they canvass for is the only view possible.
Mr. Dwivedi, which I are you appearing in? I'll be just like.
I'm appearing in writ petition 1070 of 2019 and I'm sorry, IA number 84479 of 2022. I apologize. In writ petition 1070 of 2019 and writ petition number 1162 of 2018. Both of them are by the most popular PIL petitioner in the court today.
Ms. Manohara Sharma.
No, listen. Nowadays he is not that popular, Mr. Upadhyaya.
Oh.
Your arguments, Mr. Dwivedi, have to be very brief.
Mr.
My argument was?
Arguments have to be very brief. Because Mr. Upadhyaya feels that a delay in justice is occurring, so therefore there must be very, very concise arguments and finish. That's his view in public domain.
In fact, one question which has troubled all of us is when my Lord the Chief Justice asks how much time you will take. So, now being towards the end, it won't be too long, but let me see how crisp I can be. So, these are the two fundamental basic principles. And in constitutional matters, it's always possible to take two views. Even if the basic structure doctrine was 7:6. So these are all always highly debatable. Ultimately, your lordships have to decide which is a better proposition to take place. Just as in that case, what tilted the balance was that if an absolute power is granted to amend every part of the constitution, then many of the fundamental values can suffer destruction. So therefore, that caused the tilt. But there also, lordships did not say basic structure cannot be touched. It can be abridged, but not destroyed. That was the concept. So coming to 370, my lords, I have some divergence from what Mr. Salve submitted. It's not in opposition, my lord, to what he generally submitted, but some divergence. Yes. In our camp, my lord, fortunately, there is little divergence and contrast. Unlike, because those who are claiming that that's the only submission, I find a lot of contradictions amongst the lawyers stand. Some saying something trying to say quite opposite to that. But that apart, my divergence is about the character of the power of the president. Mr. Sibal said it is executive, president's power. Mr. Salve says it's legislative. I say, my lord, that this power is a constituent power, much wider than Article 368. The fact that it is vested in the president is for the special reasons which existed when it was framed. It's a constituent power. A power, because the lordships in the 5 judges' judgment say, Puran Lal Lakhanpal 2 probably, that modify is very wide. Efface. You can say even 136 will not apply. Ordinarily, independence of judiciary, if anybody touches 136, it will be struck down as violating basic structure. So the power to modify and accept under D is very wide.